Communications Company to make its presentation. Appearing for TELUS is Mr. Ted Woodhead. Please introduce your colleagues, after which you will have 30 minutes to make your presentation. Mr. Woodhead.
Thank you, Madam Secretary. Members of the panel, I believe, and staff, I believe you have our presentation in front of you. My name is Ted Woodhead. I am Vice President of Telecom Policy and Regulatory Affairs for TELUS. On my immediate left is Stephen Schmidt. He is our Chief Regulatory Legal Counsel. And to my right is Michael Ryan, partner, Arnold & Porter LLP. Mr. Ryan is head of that firm's telecommunications group and is a recognized expert in telecommunications law. Mr. Ryan is also widely regarded and known as the author of Canadian Telecommunications Law and Regulation and has been professionally involved in numerous cases involving compliance with the Canadian telecommunications ownership and control requirements. We are in receipt of the Commission's September 16th letter that outlines the issues that you would like us to focus on, and we will deal with each of them in turn throughout this presentation, and it's structured to address those specific issues. We appreciate this opportunity that you've provided to us to give our views on this important matter, and we would be happy to answer any questions you might have at the conclusion of the presentation or in the middle of it, if you so desire. At the outset, it's important to reiterate that this proceeding is solely about Canadian law and its application. This is not a policy proceeding. This is about control in fact. With that understanding, TELUS views the entirety of the Globalive arrangement before you, an arrangement that includes a 65% equity interest in Globalive by non-Canadians and sees 98% of the debt of Globalive in the hands of Canadians. In other words, 82% of the capital structure of this entity in the hands of non-Canadians to be non-compliant with the ownership and control requirements. Beyond those indicia of control, however, are a web of other connections, control points that exist and operate to the benefit of Orascom, Globalive's principal equity and debt holder, that can lead to no other conclusion than that Globalive has yielded control to non-Canadians. On that basis, Globalive's arrangement is non-compliant and must fail. With that, I will turn the presentation over to Mr. Ryan, who will take you through the bulk of the deck that you have in front of you.
Commissioners. We have, as Mr. Woodhead has indicated, set out on slide 3 of the pack that we've handed to you a list of the issues as you identified them in your letter to parties dated the 16th of September. And each of these is, of course, important in its own way. The ones we think are key to this case, though, are the ones that tend to be towards the top of the list, and it's on these that I propose to focus in my remarks. In particular, the financing arrangements and the level of Orascom's economic participation, which I propose to deal with essentially together. Next, I will deal with the relative experience of the shareholders, and then with liquidity rights and veto rights as time permits. I don't expect we'll get much further than that. And I'm conscious, of course, Mr. Chairman, that you've already had quite a good exchange on some of the key issues, and it's evident that the panel is very familiar with the record, and for that reason, I don't want to find myself making submissions to you concerning points that are already very clear to you, and I'm perfectly happy if you push me on my way when I tend to be dealing with something that's already clear to you. By the same token, we're, as Mr. Woodhead has indicated, happy to answer any questions at any point during our presentation. I'll turn then to slide 4 and just revisit briefly something Mr. Woodhead has already said to you. The issue before you, of course, can be simply put, is Globalive controlled in fact by non-Canadians? And in the formulation of the National Transportation Agency in the Canadian Airlines case, controlled in fact means the ongoing power or ability whether exercised or not, to determine or decide the strategic decision-making activities of an enterprise. And that's a test that you yourselves have adopted in the Bell Canada case recently, and indeed in the CanWest case. What's important about it, and why I take the time to draw it to your attention again, is that it's essentially a question of fact. It's a question of fact to be determined in light of the evidence. It's not a question of policy, and therefore, in my respectful submission, it's incorrect of Globalive to argue, as it did before you this morning, as it did in its reply document filed earlier, that the Commission has a substantial degree of discretion, as they put it, to determine where it considers there to be control in fact by a non-Canadian. Whether Globalive must fully comply with the control in fact requirement is not a discretionary matter. This isn't like a situation where you're deciding whether to give a license or not, and you can bring many discretionary factors to bear. You're essentially a tribunal that will make findings of fact, and from those findings of fact, in my submission, the consequences will flow. It's not a question, therefore, of policy. Our position on the issues, turning to slide 5, is that the nature and extent of the ties between Orascom, and many of these are depicted on the next slide, the nature and extent of those ties indicate that Globalive and its Canadian investors have yielded a degree of influence over Globalive's affairs that compromises the management's ability to, in fact, act independently. So Globalive is in fact controlled by persons that aren't Canadian, and it's therefore ineligible, as it's presently constituted, to operate as a telecommunications common carrier. Now that puts, of course, potentially puts the Commission in a difficult position, but the question is nonetheless a straightforward one. And let me now turn to some of the facts that we have and the record before us. In particular, I'm at slide 7. And the level of Orascom's economic participation. As the document you yourself circulated this morning makes clear, Orascom participates in the Globalive venture through two arrangements. One is its 33 1/3 equity stake in the holding company, and the second is its 47.6 equity stake in the investment company. And that 47.6%, of course, is composed of both voting and non-voting shares. These two interests taken together translate into a 65% equity, indirect equity stake in Globalive. Over and above, Globalive is also the lender of 99% of Globalive's debt, at least working from the material that we have on the public record available to us. Assuming a debt-equity ratio of 50-50, then Orascom's economic participation in the Globalive venture is 82%. Now, this level of economic participation in a Canadian carrier or broadcaster, Mr. Chairman, is clearly unprecedented. There are 3 other cases in which the Commission has accepted arrangements where the foreign equity was in the 60 to 65% range. But the similarity between these cases and this one is superficial. And the 3 cases I'm referring to are the Persona case, which was a 2003 case which involved the acquisition of Quinte Cable. The second one is a Fundy Cable case of 1998, which involved a recapitalization of the cable company. And the third decision is CanWest itself, which was, of course, decided in 2007. And that case concerned the acquisition of Alliance Atlantis. In all 3 cases, the Commission approved arrangements under which foreign investors acquired more than 60% of the equity of a broadcaster. But there, the similarity between those cases and the present case ends. Now, there are many distinctions between those cases and this one, but there are 2 that I think are critical and worth underlining for you. The first is that in none of these other cases was the party acquiring the equity interest also a significant debt holder. In fact, the decision in CanWest makes it clear that if the foreign investor had also been a major debt holder, the transfer of control that was approved in that case might very well have gone the other way. And I draw your attention to paragraph 52 of your decision in CanWest. It's just a couple of sentences, and I'll take the trouble to read it, if I may. You say, the Commission was concerned that if a Goldman Sachs & Co. entity, which was the foreign investor, was the lead syndicator with respect to the debt, or if it were the major debt holder under any of the lending arrangements, this together with Goldman Sachs' equity interest could result in undue influence over the venture by a non-Canadian. However, in light of the evidence provided by CanWest, which clearly shows that Goldman Sachs is not the lead syndicator and is a relatively minor debt holder rather than the single large concerns in this area have been satisfied. And it's on the basis of that paragraph, Mr. Chairman, that I make the remark that I did, that if the foreign equity investor, which held in the range of 60 to 65% of the equity, had also been a major debt holder, the decision might very well have gone the other way. Now that's one distinction, the fact that the foreign investor is a financial institution, is not the holder of significant debts. The second distinction, which I think is fundamental to those three cases and distinguishes them from the present case, is that the foreign investor was in all three of these other cases a financial institution. It was not another broadcaster who would be involved in the active management of the broadcaster being acquired. Persona, Fundy Cable, and CanWest were like the ACE aviation case decided by the Canadian Transportation Agency in 2004 about financial investors. The 2004 decision of the CTA is worth dwelling on for a moment. In that case was also a case of a carrier needing to be recapitalized, in that case Air Canada. And a significant part of the money for the capitalization was going to come from an American financial institution. The CTA decided that since the source of the loans was a financial institution that had no intention of participating in management, there was no danger that Air Canada would be subject to foreign control. In the present case, the situation is quite the opposite. Orascom's business is to provide mobile telephone services. Mr. Sawiris said it several times this morning, he's not in the business of lending money. Orascom has acquired and operates mobile carriers in 14 other countries. It proposes to add Globalive to that list of carriers. The intention is clearly to run Globalive as an Orascom company, selling services under Orascom's brand, using Orascom chosen technology, and with the active participation of Orascom at all levels of the carrier's activities. I don't think that's in dispute. The implication of Orascom's 65% equity stake for control of Globalive and its very significant debt holding is clearly different than if it was, for example, a Goldman Sachs that was making that investment. Now, both Mr. Lacavera and Mr. Sawiris, and then later Mr. Campbell, were almost apologetic about the fact that Orascom is the largest shareholder and essentially the exclusive source of debt. They ask you to use a discretion to let them proceed on the understanding that they may rectify the situation later. I suspect that Industry Canada heard the same pitch at the beginning of this year when it issued the licenses. The facts, Mr. Chairman, however, are what they are. They have not changed. Globalive is frank to admit that despite persistent efforts, it has been unable to secure Canadian capital for this venture. And by the way, however, it appears that other operators haven't been having the same difficulty in securing Canadian capital. So one has to ask oneself how flexible Orascom and Globalive have been about the terms on which that capital could be secured, and whether some of the terms and conditions that are already embedded in the investment documents aren't themselves inhibiting the attraction of additional capital from Canadian sources. That's all I propose to say about the about economic participation. I do want to turn next to the relative experience of the shareholders. And I'm on slide 8 at this point of my presentation. This is not, by any stretch of the imagination, a merger of equals. As the Financial Post put it in an interview with Michael O'Connor in April of 2008, Orascom's operations dwarf the Canadian market. The company has revenues of $5.3 billion. It has operations in 14 countries. It is no disrespect to Mr. Lacavera, who has obviously been very successful in earlier ventures, to make the point that he is not, and AAL is not, in the same league as Orascom. Neither Mr. Lacavera nor his company, GCC, simply have experience in mobile telephony. They are looking to Orascom to provide them with that expertise. Their position is a very subordinate one because of the difference in the relative sizes of the companies. GCC's annual revenues amount to about $125 million per year, which is only about what Orascom earns in a week. Now, the Unitel case, for those that remember it, is an interesting point of reference on this issue of relative experience of the shareholders. You'll recall, Mr. Chairman, that AT&T acquired a 30% stake in the Canadian carrier Unitel back in the 90s. AT&T is, of course, a formidable force, as Orascom is, in the telecommunications business. But its influence in the Unitel venture was counterbalanced by the fact that Unitel's two other investors were themselves major Canadian corporations. Those were Rogers and Canadian Pacific. The transaction simply did not raise the same concerns about foreign control that arise in a case such as this, where there is such inequality between the two participants. It has to be said, Mr. Chairman, that there's no reason to think, in fact, that Orascom would have any interest whatsoever in partnering with AAL or with GCC, except for the fact that they are Canadian. And as Canadian entities, they bring that critical asset to the Globalive venture, the fact that they're Canadian. I'd venture to suggest that there is nothing else that GCC or AAL brings to the party that Orascom could not replicate itself. The documents before you make it clear that AAL is essentially peripheral to this venture. And I say that for two reasons, and those are reflected on slide 9. Now, the facts are changing as we speak a bit on this first point, but starting with the documentation as it existed prior to this morning, AAL has a unilateral right to put its shares to a third party. That provision would never have been agreed to, Mr. Chairman. It hardly matters whether it's still there or not, if AAL were seen as bringing any vital skills to the Globalive venture apart from being Canadian. Now, if I understood the new evidence this morning, that put option will not be exercised during the next 3 years. But it doesn't take the issue off the table. The second reason, stemming from the documents itself, that I say that Mr. Lacavera and AAL are expendable, is that Globalive has the right to terminate the consulting agreement with AAL if AAL ceases to own 3% or more of Globalive. In other words, if it were essentially to be an Orascom company. If AAL were seen, Mr. Chairman, as important to this venture, the consulting agreement would contain a term requiring AAL to continue to provide services even if it ceased to be a shareholder, not the opposite. Let me turn next to the subject of liquidity rights, and this is a subject on which there has been already some important exchanges this morning. You said, Mr. Chairman, that you were stunned by one of the terms that you found in the agreement, the drag-along rights, and I have to say, TELUS shared your reaction. I would not be surprised to find in an agreement of this sort a provision allowing Orascom to sell its shares to a third party, or allowing Orascom to put its shares to other investors for purchase by them in the event that it wanted to exit the business. It's reasonable for an investor to include provisions like that give it an opportunity to exit and put its shares to other investors for that purpose. But this agreement goes way beyond providing Orascom with an exit strategy. It gives Orascom the right, acting unilaterally, to sell the entire company out from under the other investors at a price of its choosing, at a time of its choosing, and subject to compliance with the definition of eligible person, to a person of its choosing. Let me be clear on this. Orascom not only has the right to sell its own shares, it can require all of the other shareholders to sell theirs as well. This is called a drag-along right for a reason, because essentially it would allow Orascom to drag along unwilling sellers to a closing. Nothing could say more clearly, Mr. Chairman, than this provision does about who is really in charge at Globalive. Globalive is, for all intents and purposes, an Orascom property. Orascom's rights do not stop there. Instead of selling the whole company, it can selectively require AAL to sell its shares to a purchaser of Orascom's choosing. Now that's subject to the evidence we heard this morning that I'm still trying to assimilate on that point. No other shareholder has anything resembling reciprocal rights. You should attach, in my respectful submission, a lot of importance to this configuration of obligations under the shareholder agreements. Let me come next to the question of vetoes. This is an area that's already been well canvassed. I want to make only a few simple points about these provisions that appear in an appendix to the two shareholder agreements. Under these arrangements, Orascom has essentially a lock on decision-making on all key issues. It can veto not only expenditures in excess of $5 million, as was pointed out this morning, or borrowing in excess of $20 million. It can veto any change to the business plan that would change projected revenues, expenses, capital, or cash flow by more than 10%. Since the business plan is a document that was agreed by the shareholders as part of the arrangements that established Globalive, that business plan is in place, and it puts management in the position that it can't vary from that plan determined by the shareholders by more than the indicated percentage without going back and securing Orascom's approval. Orascom also has a veto on the issuance of new shares. And I appreciate, Mr. Chairman, that Orascom and the other parties are talking about instituting a share option plan or a stock option plan that would allow benefits to be given to senior executives. But the point is not whether there is a stock option plan or there is not a stock option plan. The point is that there can only be one if Orascom agrees to it. It has a veto over that, as well as any other issuance of new shares, such as, for instance, to a potential new investor. So if a Canadian investor were found, Orascom has a veto over that party participating in this venture. In the same vein, it has a veto over mergers. The $5 million limit, which has already been the subject of some discussion, is, I think as the Commission has recognized, a very low limit for a capital-intensive business such as this one. Just as the $20 million limit is a very low limit for borrowing when you consider that the company has debts in excess of $500 million. So even swapping that debt out for other debt will require the consent of Orascom. And it's for this reason and others related to the exercise of these vetoes, which go beyond the subjects that I've mentioned, that I say that Orascom has a lock on decision making. Let me also make a brief reference to the trademark license agreement. We don't know what the term of this agreement is. It's been suggested that the terms are very generous to the company. Commissioner Menzies asked questions about where the inspiration for adopting the Wind brand came from. The answer essentially was from within Globalive. I think that leaves unanswered, however, whether it was the Orascom people within Globalive at the board level that suggested it or otherwise. But in any event, if this is an agreement of short duration, and we at TELUS simply don't know based on what we've been able to see, the CRTC has to be concerned. If it is less than 5 years, the CRTC should be very concerned. Globalive would be very vulnerable to the influence of Orascom, quite apart from any of the other factors that I've mentioned, if Orascom threatened to terminate the rights to the brand or not to renew the trademark license agreement upon its termination. It's hard to think of anything more vital to the future success of the company than it being able to benefit from the investment that it's going to be making in the development of its own brand in the marketplace. And so to have the potential, even if it's not exercised, for that to be pulled away from it is a very formidable threat. The last subject I propose to address is the advisory services agreement, and I'll again propose to be very brief. The Commission is on to this one. The investment agreement makes it a condition of the Orascom investment that Globalive should execute the technical services agreement. It may be a good agreement. It may be very favorable to the company. It may be exactly what the company would want in all its wildest dreams. I don't know. But the point is, whether it's a good idea or not, it's not at the choice of management that it's entered into this agreement. It's been dictated by Orascom at the shareholder level as a condition of its investment in the company. It's not so much what the content of the agreement is, in my respectful submission, although it gives Orascom very extensive influence over a number of very important matters. It's the fact that Orascom can insist that this agreement be executed that's important for your conclusion at this stage of this proceeding about whether Globalive is controlled in fact by non-Canadians. And I think it was you again, Commissioner Menzies, that noted that that Globalive has to pay under the terms of that agreement whether it uses the services or not. That again is an indication, I would submit, of the authority, the influence that Orascom is bringing to bear on this venture. To conclude, I'd respectfully suggest that the CRTC has never endorsed an arrangement which gives a foreign entity such wide-ranging influence over the operations of a telecommunications common carrier, or for that matter, a broadcaster. Taken in their totality, the nature and the extent of the ties created by the various arrangements that the parties have entered into indicate that Globalive and its Canadian investors have surrendered control of this company to a foreign company. TELUS respectfully submits that the evidence invites only one conclusion. And it's not a question, Mr. Chairman, about whether there should or should not be more competition in the wireless business. The government has decided that there will be more competition, and there will be competition whether there's a Globalive there or not. And it's not a question of whether Globalive is competent to provide that competition or not. I'll assume that they are. the only question that needs to be decided is whether they're Canadian or not. And it's to that question I suggest that there's only one possible answer. Not being a Canadian company, the consequence is that they are not eligible to operate as a telecommunications common carrier as they're presently constituted. Those are